Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, this has been a real roller coaster of a couple of weeks when it comes to this particular Department of Justice. Seems like just about every time they're about to turn a corner and we're going to give them a thumbs up, they do something crazy. And then once they do something crazy, the facts of that change. And it's just this never-ending, rather exhausting process that we're going through. We're going to talk about what I believe is a big disappointment from the Department of Justice, and I think you may think that as well, especially if you are of the opinion that any defense of the National Firearms Act by the Department of Justice means that they are, in fact, not a pro to a Department of Justice. If you are of that opinion, then you're going to be very disappointed when you hear about this. It appears that the United States Department of Justice is more than willing to fight vehemently in support of the National Firearms Act. We'll go through their pleadings right now from the Fifth Circuit. So today, let's spend a few minutes and let's talk about DOJ Goes All In on Defending the NFA. Okay, America, we have talked about this case multiple times. This is a challenge to the federal regulation of suppressors. The case is United States v. Peterson. The statutes which are being challenged here are 26 United States Code sections 5841, 5861D, and 5871. This is the case where you may recall that the Fifth Circuit actually first found that suppressors were not even protected by the Second Amendment. The Department of Justice was at least willing to weigh in on that and say, no, that's probably not correct. Then a three-judge panel found that there was absolutely no constitutional deficiencies at all with the National Firearm Regulations of suppressors. Peterson then moves for en banc review to have the full Fifth Circuit hear this case. And the United States Department of Justice has filed a motion in opposition to that en banc review. So they're basically saying, panel got it right. There's no reason to have a rehearing on this at all. So we could just end the video right there and just say, okay, so with that information that they are going to vehemently fight to uphold the National Firearms Act as it relates to suppressors, what do you all think of that? But we got to do a little bit more geeking out than that, and that means we got to actually take a look at the arguments. And this is where, in our opinion, and again, you get to decide for yourself, things get even worse here. Because I would characterize the arguments as two things. Number one of their arguments is immensely weak, and the second argument they make is immensely dangerous. What do I mean by weak? Well, although the constitutionality of these applicable statutes are in play, the United States Department of Justice wants to essentially short-circuit any type of constitutional inquiry and basically just say, hey, listen, every single case that's ever looked at the NFA before has found it to be constitutional. Yeah, granted, the rules may have changed and the whole groundwork upon which it exists may be different, but it doesn't matter because it's all still good case law. The Department of Justice actually wrote in their brief in opposition to the en banc review, Peterson fails to show the panel's decision conflicts with the decision of this court, the Supreme Court, or any other court of appeals. Peterson implicitly recognizes the panel decision is consistent with this court's jurisprudence by asking the court to reconsider its earlier precedent of McCrory that recognized the presumption of constitutionality for certain firearm licensing laws. But because McCrory relied on what the United States Department of Justice believes valid constitutional principles, there's absolutely no reason to go back and take another look at it. Or as they put it, this case would be a poor vehicle for reconsidering McCrory, given that the NFA's restrictions on suppressors are constitutional regardless of the presumption recognized in McCrory. Okay, and then we get to the dangerous part of their arguments, and their dangerous part of the arguments is really twofold. Number one, there's a heavy reliance by the United States Department of Justice on Bruen footnote 9, which we'll talk about in a second. And number two, they really kind of show you what they think about the use of suppressors. Now, Bruen footnote 9, we have talked about it way too much, especially for something that is a footnote, but in some pertinent parts, Bruen footnote 9, which upheld many shall issue carry licensing regimes, stated, to be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes under which a general desire for self-defense is sufficient to obtain a permit. It appears that these shall issue regimes, which often require applicants to undergo a background check or pass a firearm safety course, are designed to ensure that only those bearing arms in the jurisdiction are in fact law-abiding responsible citizens. and they likewise appear to contain only narrow, objective, and definite standards guiding licensing officials. Now, that was meant to be a shield from frivolous lawsuits against a lot of other states' shall issue licensing regimes, but it has been turned into a sword by those in the civilian disarmament movement. And in this case, the United States Department of Justice also believes that, well, the NFA is basically a shall issue licensing regime. It was totally okayed in Bruen footnote 9, and therefore it standing alone, the NFA standing alone, is in fact constitutional because they authored in their brief in opposition. The panel explained the NFA's suppressor licensing scheme denies an application based only on the objective and definite licensing criterion that the persons making or possessing the suppressor would violate the law. Also, the record was devoid of any facts indicating that the NFA has been put towards abusive ends as applied to Peterson, or that a $200 tax as applied to him would deny him his Second Amendment rights. Thus, Peterson had not overcome the presumption that the NFA's shall issue regime was constitutional. And I know that may seem a little offensive to some of you, and it is, but I want you to consider the danger that comes when your United States Department of Justice authors statements such as, instead the panel reasoned that like shall issue license to carry laws, the NFA does not outright prohibit suppressor possession, but rather merely conditions the possession on proper criteria. Additionally, the panel reasoned that Peterson had not shown that the NFA's $200 tax operated to deny him his Second Amendment rights. Nothing in the panel's decision conflicts with the Supreme Court's decision regarding unconstitutional taxation. So with those words, being the words of the United States Department of Justice, just think what states like Illinois, New York, New Jersey, California, Washington, and any of the other big civilian disarmament states could do with all sorts of extra shall issue objective criteria that all have a cost associated with it. But then in discussing another case that dealt with costs to carry licenses, Coons versus New Jersey, in dismissing the Coons case, the United States Department of Justice also began to pull the veil back on how they truly see suppressors. They may have been willing to write to the Fifth Circuit that they believe the Second Amendment was implicated, but it would appear that that's about as all they're willing to do here, because I want you to take a look at this language. Coons did not involve the NFA, but rather an entirely different state law. Also, Coons involved the burden on the public carry of handguns, the quintessential self-defense weapon, whereas this case involves suppressors, a useful but non-essential firearm accessory. And if you think that's just one singular incident of inclusion of sloppy language, I would like to think so also, except it appears again and again, because the United States Department of Justice also states, the NFA regulation at issue does not target ordinary firearms such as handguns, but only non-essential firearm accessories that are uniquely adaptable to criminal misuse. Law-abiding citizens remain free to possess suppressors so long as they register them. Also, recent legislative changes mitigate Peterson's taxation concern. And again, they triple down on it when they say, as the government's previous filing made clear, registration laws or taxes on ordinary firearms would trigger a different analysis, because such laws would impose a more severe burden on the right to keep and bear arms. Okay, so if you ever thought that the United States Department of Justice might cooperate in any way, shape, or form with the slow dismantling of the National Firearms Act, that ship has absolutely positively sailed, and that is not going to happen. Don't believe me? Go ahead and read the brief in opposition in the case of United States of America v. Peterson, because we linked it up down below in the description box. You don't have to take our word for it. Obviously, I'm interested to hear what all of you think, and how does this weigh in your overall assessment of where this Department of Justice is right now. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.